order. As soon as we get the thumbs up that we're resuming.
Representative Craigo,
Here.
Representative Chestick,
Here.
Representative Harrelson, Representative Jennings, Representative Nemec, Representative Oakley, Representative Provenza,
Here.
Representative Rodriguez Williams,
Here.
and Chairman Washut.
Here.
Thank you.
All right, thank you. So I have a few procedures to go through. Takes just a little bit. Bear with me. Welcome to the 67th annual session. Please turn off your cell phones or turn them on to mute. If you need to make a call, please leave the room. If you intend to propose a substantive or lengthy amendment to a bill, we will need a written copy for each member and 2 for our staff. If you need assistance making copies, you can go across the hall to the copy center and Ms. Dent will assist you. This meeting is being streamed live on the legislature's website. A link is located on the calendar page. Those not wishing to offer testimony online are encouraged to observe the proceedings on the Wyoming Legislature's YouTube channel. The order of testimony today will be the bill sponsor and sponsors witnesses, the other legislators wishing to testify, state agency and court officials, representatives of interested organizations, and members of the general public, both online and in the room. We ask all of those who are seeking to testify to press the microphone button until the green light appears. Say your name, and if you are new to this, please spell the last name. Please speak clearly, speak up so the committee, those in the room and our listening audience can hear you and understand you. Then add the agency or organization that you represent. If you are here as a private citizen representing yourself, please tell us where in this great state you reside. Remember that all dialogue must first be addressed to the chairman. Witnesses are expected to remain polite and civil during their testimony. Audience members online wishing to testify should register now using the testify button provided on the committee's meeting notice. Those registering will be emailed a link to participate in the Zoom platform. Handouts for the committee should be transmitted to each committee member. Audience members are encouraged to watch the proceedings via YouTube. For those online, at the time that I call for public testimony on a topic, if you wish to testify, raise your virtual hand. You will be called on as time allows. Staff will then modify the attendees' credentials, at which point they will need to have their video turned on and their microphone unmuted. Following testimony, staff will then modify the attendees' credentials as needed. Public testimonies will not last longer than 3 minutes unless an extension is granted by the chair. I will have access to see which attendees have raised their hands, and I will do my best to indicate who is up next or on deck so you can prepare. Once a virtual attendee has concluded testimony or does not anticipate providing testimony, please monitor the proceedings via YouTube so that others can join the meeting, because there is a limited number of people who can be queued to provide testimony online. So the bill or bills being discussed are located on the meeting calendar page, and we will now begin with House Bill 14. Where you out just reading through the introductory comments. So House Bill 14, civil case filing fees amendments, sponsored by the Joint Judiciary Interim Committee. Ms. Butler. Since this is a committee bill, perhaps you would be kind enough to give us the background on it.
Good morning, Mr. Chairman, members of the committee. My name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. So this bill comes to you today as a committee-sponsored bill out of the interim 2022 interim. What the intent of this bill is to make the filing fees in the district court consistent. So right now, the way the filing fees exist is you pay a different filing fee for a probate than you do for a general civil case filing. This bill would just make those two consistent. That is helpful in a number of different ways. One is that it creates less confusion for the litigants who come into the courtroom. Two is it assists as we move to a more automated system. So when we get to e-filing, it becomes less of a burden for the clerks to make sure that they have verified which kind of case filing it is as those filings come in. And the third just is a fairness issue. So in some district courts across the state, in the district court clerk's offices, for guardianships in particular, people are charged the probate filing fee, which right now is a little bit higher. And in some district court clerk's offices, they are charged the general civil filing fee, which is a little bit lower. And so this just evens the playing field, makes sure that in all district court clerk's offices across the state, that filing fee is the same for all civil cases. That includes both general civil cases and probate cases across the state. So that is the intent of this bill. That is what this bill does. And Mr. Chairman, I'd be happy to stand for any questions.
Committee questions for Ms. Butler? Representative Chester?
Yes, Ms. Butler. Thank you. I'm new to the committee and new to the legislature, actually. I was a lawyer in Pennsylvania, and my questions may be a little bit off target because practice in Pennsylvania is different than it is here in Wyoming. I'm familiar with how we did things in Pennsylvania. But so the main intent here is to consolidate probate actions with other kinds of litigation lawsuits and have the same basic filing process. Is that what you're saying?
Mr. Chair, Representative Chestick, not necessarily. The intent really is just to make the filing fees the same. So when you file a probate filing right now, the filing fee is $160. If you file a general civil case in the district courts, it's $120. And so really the intent is just to make those two fees the same.
Okay. So
Representative Chestnut.
Mr. Chairman, thank you. So the language, each civil action, to me, when I see the word civil action, I think lawsuit, right? That's a civil action. That's the rules of civil procedure defines a lawsuit as a civil action. Probate proceeding, do you consider civil action to cover probate proceedings? So that seems like a little bit one-off to me.
Ms. Butler.
Mr. Chairman, Representative Chestick. So the probate fees are in a different title within the statute. So they're under Title II, and the civil actions exist kind of all over. But the filing fees themselves are also in two different titles. So the probates are in Title II for probates and Title V for civil filings. So generally probates are civil cases, but they're not really civil actions. So I would agree, yes, they're two distinct types of cases within the district courts, and they will remain that way.
Ms. Butler, could you clarify that in Wyoming, unlike many other states, we do not have a separate probate court, that both these proceedings take place in the same court? Is that correct?
Mr. Chairman, it is to a degree. So there is a probate court under Title II, but it exists within the district court. So essentially what happens is the district court judges get to wear many, many hats as those judges. So they act in juvenile court, they act in probate court, and they act in general civil court. It's all within the district court, but they preside under those different titles. And so they're, when they're under Title II, they're in probate court. When they're under Title 14, they're in juvenile court. So it just same judge, but different roles.
Representative Chestnut, do you have a follow-up?
Yes, I do. So I have some questions about other parts of this section A1. The language that's there now is for filing instruments or documents in each civil action and certifying one copy of any order, decree, or a judgment at the time of its filing for each party. That is really confusing to me. I don't really understand. It sounds like every instrument or document you file gets charged the same fee, which I don't think is the intent of this. So can you explain what certifying one copy of any order, decree, or adjustment at the time of filing for each party, what does that cover? What is that supposed to be about?
Ms. Butler.
Mr. Chairman, Representative Chestick, I am not entirely sure, but what I can tell you is we have a district court clerk in the room who probably has much more experience in that than I do. Diane Sanchez from the Laramie County District Court is here with us today, and I think she would better be able to answer that question than I would.
If she's intending to testify, I'll save my questions for her.
Very good. Any other questions for Ms. Butler? Seeing none, thank you.
Thank you.
Oh, Ms. Representative Jennings.
I was in sidebar conversation, Mr. Chairman. So Ms. Butler, I just have a little question in this day and age where government in the state of Wyoming's approaching 2 billion extra dollars and inflation is hitting all of the hardworking folks out there. Did you give any thought to actually lowering the 160 down to the 120 so they would be even?
Ms. Butler.
Mr. Chairman, Representative Jennings, that was a discussion during the interim. I think, and I can't speak to why the committee decided as it did, but what I can tell you is there are probably a number of reasons. First of all, the number of filings are not a lot. We don't have a ton of filings in the state of Wyoming, so the amount of money that is increased is fairly minimal. I will also tell you that the filing fees in Wyoming are small in comparison to other states. And then the other thing is the district court clerk. So the additional fee would go to the district court clerk's offices across the state, the counties, essentially. And the amount that they charge or that is charged for filing fees right now statutorily is not enough to cover the costs of that office. So the counties have to pay additional money to support the district court clerk's offices across the state.
Representative Jennings, follow up. Very good. Any further? All right, Ms. Butler, stay close. We might have further for you.
Thank you.
Oh, Representative Provenza.
Thank you, Mr. Chairman. Sorry. I vaguely recall during testimony in the interim that there was some sort of aid for folks who might be struggling to pay for this, but had standing. Am I correct in that?
Ms. Butler.
Mr. Chairman, Representative Provenza, there is a mechanism for a fee waiver in some cases. Generally, that's done court by court. It's not by rule or by statute currently, but there is some courts do allow a fee waiver, and I believe there is a United States Supreme Court case that requires it in some circumstances.
Follow up? Done? All right. Thank you, Ms. Butler. Please stay close. Whoa, Representative Haroldson.
Thank you, Mr. Chairman. Sorry, guys. Ms. Butler, I guess, so you said that the concept here is to bring everything to kind of the same playing field, and that it would, for the plaintiff, it would make it easier. You basically said be clearer, but I'm kind of confused as to why that would help clarify something. Obviously I see where it's $160 no matter what the court case is, but the reality is I don't know how that would make it clear. So if you could speak to that.
Ms. Butler.
Mr. Chairman, Representative Haroldson. So when attorneys or litigants file different kinds of cases, they have to pay these two different filing fees. What I can tell you is it's not entirely clear all of the time which kind of case you're filing into, whether that's a civil case or a probate case. And so that creates a little bit of confusion for litigants and attorneys, and it creates an additional burden for the clerks, because if somebody files, especially electronically now, with the wrong filing fee, the clerks are left with dealing with kind of cleaning that up and making sure the correct filing fee comes through.
So Ms. Butler, that the guardianships, and what was the other category where you said sometimes there was a disparity between districts?
I believe it's generally just guardianship and conservatorships. But again, I think Ms. Sanchez can probably speak to that. And if there are additional types of cases that come through the courts where there's a varying fee, she would know better.
Thank you. One more time. Anybody else? All right. Would our clerk come forward, please? Good morning. Welcome to Judiciary. Please state your name for the record and which district you're from.
Mr. Chairman, my name is Diane Sanchez, and I am the Clerk of District Court here in Laramie County.
Please proceed if you have something to tell us.
So as we ask for this fee to be consistent, I would just like to bring out that this really is fixing a fee or the House Bill 125 in 2019. And how that happened was by two words. In one of the statutes, it says in addition, which is for the civil filing fee. And in the probate filing fee, it says shall. And the difference there is the fees that are going to the court automation, because in the civil fees, it says that it will be in addition, or it will be collected as a shall. And in the probate, it's in addition. So it raised that fee during that time. The clerks would like for the consistency, and especially with e-filing, Laramie County has already gone on to e-filing as one of the pilot courts. And what happens is if the attorney chooses the wrong fee, then the clerk has to go back traditionally to try to collect the correct fee, or we would have to issue a check for a refund if they were to pay extra. And the inconsistency with the conservatorships and the guardianships is it depends on an opinion as to if it truly falls under the probate umbrella or if it falls under the general civil. And there is differences as to how our judges view that and how our county attorneys view that. And so that's where the difference has actually come from, and why some clerks are charging the 160 and others are charging the 120. We would like to eliminate the confusion for the public attorneys regarding our filing fees. And we would like to help ensure that there is a smoother transition with the e-filing. Being a pilot court, I can tell you there are many bumps with this change. One that I definitely feel that is going to be a huge advantage for our community and our state, but definitely things are needing to be worked on. The fee is minimal. When you look at what other states are choosing, we are very low compared to what the other filing fees are around the states. We also have a one-time filing fee where other states will charge for many additional pleadings that are being filed, such as an answer or a counterclaim. And so we definitely just have the one filing fee that covers everything. Filing fees do not generate revenue above and beyond the County of District Court's expense budgets. Matter of fact, those fees do not go directly back to our budgets. They go into the county's general fund. And with that, I will stand for questions.
Representative Chestnut.
Chairman, Representative,
Representative Chestnut.
Thank you.
sorry.
Thank you, Ms. Sanchez. I do have some questions, several questions for you. First of all, the conservatorship, guardianships, that's all being handled by a different section of this, a different statute, right?
Chairman, Representative.
Ms. Sanchez.
Yes, that is correct. It is honestly, it's under the umbrella of the probate filing as far as where the statute is written. But there is some opinion that it really does belong in the civil umbrella.
Okay.
Representative Chestnut.
So the section that we're amending here, 53206, is intended only to cover the typical litigation in district court, the plaintiff files a complaint, there's answers, and that's what this, the only section we're amending covers the civil actions, right? The litigated part matters. Is that correct?
Chairman.
Ms. Sanchez.
Representative, that is correct.
Okay, so
Representative Chestnut.
thank you, Mr. Chairman. So now I'll ask you the question I asked Ms. Butler a moment ago. I am very confused by the language and certifying one copy of any order, decree, or judgment at the time of its filing for each party. Can you explain to me what that means?
Ms. Sanchez.
Chairman, Representative. So after an order has been signed by the judge, the clerk will file stamp that document and certify for the copies to go back to the attorneys. And so that covers that fee. I don't understand as well as to exactly why it falls under this statute, but it definitely has in past history, but that is all covered together. And normally for a certification fee, it's 50 cents. So if you had a litigant that came in and wanted us to copy or to certify a copy that they already had, we would charge 50 cents for that to happen.
Mr. Chairman?
Representative Chesney.
The problem with that is that that language appears in a section that attaches a $160 filing fee to it. So instead of 50 cents, the section seems to say you ought to be charging $160, which I don't think is the intent, but that's how it reads. So that's I'm getting at the amendment. I'm going to be proposing an amendment in a moment that changes all that language to say, for filing a complaint or other document that initiates a new civil action, and that would be the $160 fee and nothing else. Would that amendment be agreeable to the clerks?
Ms. Sanchez.
Chairman, Mr. Representative, yes, that would be. And I think that what we have been looking at is on the second page where it says original filing fee. And so perhaps that other part has not been paid as close to attention.
Okay, thank you.
Other questions for Ms. Sanchez? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Ms. Sanchez, web developers can be pretty creative, and I'm curious if there's been any efforts of the e-filing website. Has there been any efforts to make it more user-friendly so that users aren't confused with the amount that they're paying for?
Ms. Sanchez.
Mr. Chairman, Representative, honestly, I believe Ms. Butler would be better to answer that. Even though I am on the e-filing, we do not see the side as to what the attorneys or the litigants see. We just see the clerk side of it, which is really our case management system.
Follow up, Ms. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Ms. Sanchez, just follow up. Do you know how many waivers are granted statewide in district court, and who pays for that? Who does the burden fall under?
Ms. Sanchez.
Mr. Chairman, Representative, I do not know the number of how many waivers are done, but I can tell you that falls on the county, because then we proceed with all of our normal processes without a filing fee.
Representative Jennings.
Yeah, Mr. Chairman. So I have a couple of questions. So this body, I sat on this for 4 years back a while when the e-file was, and we were kind of sold that as an efficiency that was going to make things all easier and it was going to be more efficient. So I guess my first question is here we are, we're apparently not realizing an efficiency. And secondly, I'd kind of like to hear your association's discussion a little bit on why you chose that when the state's flush with money, the counties have got plenty of money and the cities have plenty of money. But the inflation's hitting the public, same as it is everyone else. Everything is going up.
Mhm.
And so why did you choose to go up instead of bringing it to, say, the 120?
Ms. Sanchez.
Mr. Chairman, Mr. Representative, I really do feel like it is a modest fee when you look at the number of cases that are being filed across the state. And as you said, our costs also are going up in order for us to run our offices. And so for all of our supplies that we also need, we are paying additional funds.
Representative Jennings.
Thank you, Mr. Chairman. So am I to understand that e-file was not an efficiency? It did not bring savings?
Ms. Sanchez.
Mr. Chairman, Representative, possibly in the future, but we are not there yet. And part of the reason is because e-filing is not mandatory across the state because it is not rolled out all across the state. So we are dealing with paper as well as e-file documents. So our processes still include all of those fees that we have endured in the past at this time. Do I feel like we are going to get there? Yes. But are we? No. And is it going to take some time as with all new products? Yes.
Any other questions from Ms. Sanchez? Representative Craigo.
Thank you, Mr. Chairman. Just for clarity, Ms. Sanchez, going back to the whole discussion regarding guardianships and conservatorships, the reason we need to clear up this is because each county can and sometimes does treat that filing fee differently amongst the counties. Is that correct?
Ms. Sanchez.
Mr. Chairman, Representative, that is correct.
And so the system,
Representative Craigo.
oh, sorry, Mr. Chairman, thank you. So Ms. Sanchez, so the system, our e-filing system is based on one level of fee, even though the counties may treat that differently at the county level, correct?
Ms. Sanchez.
Mr. Chairman, Representative. So what happens when a litigant is filing by e-filing, they choose which umbrella they want to pay. And so if you are correct, if the county is one of those that charges $160 and they choose the $120 fee, then the clerk would have to contact that attorney and ask them to submit the remaining part of that fee. And that would have to be submitted traditionally, because once those documents are filed, you cannot go back through the e-filing system to gain those fees. Or on the other side of that, if they chose the $160 and it was a county that's charging the $120, then we would have to cut a check back to that attorney.
Representative Craigo.
Follow up, Mr. Chairman. Thank you. And so, Ms. Sanchez, this bill is an attempt to essentially eliminate that inefficiency.
Ms. Sanchez.
Mr. Chairman, Representative, that is correct.
Thank you.
Other questions for Ms. Sanchez? Ms. Sanchez, off the top of your head, do you know what some of the neighboring states charge for their filing fees?
I do not have that with me today. I most certainly can furnish that if you would like it. We have definitely looked into that, and I just neglected to bring that with me today.
Thank you, Ms. Sanchez. Any further questions? All right, thank you much. Anyone else in the room wishing to testify on House Bill 14? Good morning. Please turn on your little green light and tell us your name and what you want us to hear.
Good morning, Mr. Chairman, members of the committee. My name is Christy Arneson. I'm the Senior Administrator of the Economic Security Division with the Department of Family Services, which oversees the child support program. We're just here today. I sent you an email on Friday, which I'm not sure if you received, but we have no concerns with this bill, but just here we have a fiscal impact, which I hope you also were able to see. If not, I do have copies. The child support program, as well as our social services program, but especially our child support program, is a very large filer with the court, and we pay filing fees. And this is just an ask. I sent a proposed amendment as well to delay the effective date for state agencies so that we can ask for money in our budget to pay for filing fees going forward due to the increase. And I'm happy to take any questions.
Thank you. Any questions for Ms. Arneson? Representative Jennings.
Thank you, Mr. Chairman. Ms. Arson, if you get an exemption to this, won't that create confusion and more problems back to the clerks?
Ms. Arneson.
Mr. Chairman, Representative Jennings,
I don't know if it will cause confusion for the courts. I can say for the program's perspective, it will not cause confusion.
Further questions? Ms. Arneson? Thank you. I did receive, I think the committee has received your amendment proposal. Thank you.
Thank you.
Anyone else in the room wishing to testify on House Bill 14? Anybody in Zoom land? All right, public testimony closes. Committee, your preference?
Move the bill.
Moved by Representative Chestnut, second by Representative Crago. Any proposed amendments? Representative Chestnut?
Yes, thank you, Mr. Chairman. I have, and I apologize for not including the line numbers. I'm new to this. I'm figuring it out as I go, but it's been distributed to you in paper. It's amending, starting on page 1, line 15 through page 2, line 2, that first section for filing instruments. That's what that language is. I want to strike all that language and replace it with a simpler statement for filing a complaint or any other document that initiates a new civil action. Since the guardianships and conservatorships are handled in a different section, we don't need to worry about that. This section, I believe, is intended only to deal with civil actions, lawsuits. I just think this language is clear, but also I think eliminating the part about any order, decree, or judgment, that creates a great deal of confusion in my mind. And I think grammatically, I think because it's in a section that also includes the $160 filing fee, it sounds like every time you get a copy of any order, decree, or judgment, you have to pay $160, which I don't think is the intent, and I don't think it's the practice either from what I've heard. So I think this clears up that ambiguity by striking that language completely and just replacing it with the more simple language that I proposed at the bottom of my amendment.
There's a second to the amendment. Seconded by Representative Provenza. Discussion on the amendment. Representative Crago.
Thank you, Mr. Chairman. So I agree that the current language is inartful. It's not very clear, but it does serve a purpose. And the purpose it serves is to make clear that as a filing party, you only have to pay the one initial fee. And that initial fee gets you certain services, which is the filing of instruments or documents. So that's the first set of words within that clause. So when you pay the one, at this point, 120, if we pass this bill through the chambers, it'll be 160. But for the filing of instruments or documents in each civil action, you pay the fee. You also get a certified copy. It's very clear, you get one certified copy of any order that's signed by the judge, comes to you with a stamp and a seal on it. If you want an additional certified copy of an order, you have to pay for that. Essentially what this is doing is preventing the district courts by statute from charging us any fees for filing of documents as you go through the civil litigation process. It's putting a cap on what they can charge us. Otherwise, essentially by rule, they may be able to go create other fees. This is saying you, Supreme Court and District Court Conference, can't charge additional fees that would go to the counties, the state, et cetera. We're putting a cap on it. And if you go and look up the fees for probate, which is in 22401, it has the same language. It's just more artful in how they describe it. It's actually set out in its own subsection within the statute versus this big long clause. But that's the purpose of that language. I agree it's not great, and maybe someday we could work on changing that. But if we take it out, as you're proposing, we're going to run into issues within the district court, and then we're going to have two statutes that don't match each other again, which is what we're trying to solve today. So I'm going to ask for a no vote on the amendment.
Representative Chestnut.
Mr. Chairman, thank you. The rest of Section A has a bunch of additional fees that are to be paid for different things, for a deposition notice, for taking certificates of seals, for there's a whole list of 9 other things that are. So when you say that the initial fee of 160 covers everything, that's not really true, because there are 9 other things that you pay additional fees for. That's when I'm trying to look at this holistically. And the language, if you're interpreting this language in Romanet I, as covering everything, it doesn't say except for the following 9 things. So we have that, there's that problem. So it looks like things are cumulative. And I'm concerned that this can be interpreted to say that it may be inconsistent with other language. One of the later Romanettes says when you want to get a certified copy of something, you pay 50 cents, which is what the practice has been to charge 50 cents apparently. So there's an internal inconsistency between Romanet I and one of the Romanet 5 for each certificate and seal for 50 cents. So I think there's an ambiguity there that needs to be cleared up. And I would still argue for a yes vote on the amendment.
Members, the other possibility is that interested members of the committee might take a little time and draft a committee of the whole amendment rather than passing an amendment today, that if there's some disagreement about what's the right way to proceed in terms of clarification of the language, I think everyone prefers less ambiguous statutes rather than more ambiguous statutes. So that's the other possibility, is that we don't necessarily have to address this amendment today in committee. Representative Oakley.
Thank you, Mr. Chair. So I agree with Representative Craig on this. Sometimes it might seem wordy, but the words are important. And so what this says, I think there's 2 things that are taken out with the amendment that need to be included. So as Representative Crago said, for filing documents in each civil action. So that kind of covers the entire action instead of saying just a new civil action, as he referred to with, then could they collect fees every time? And then also, then it says, and certifying 1 copy of any order, decree, or judgment, which that's the final piece, right? When you get an order. So it kind of goes through the entire case. So for filing it in a civil action, and then through certifying that copy of the order, the decree or the judgment at the end. So it kind of goes through the entire case, where then just taking that out just seems to take out the entire case, the entire process. And I don't know why we do that. And I kind of feel like that's not what is in front of us today. So I agree. I would ask for a no vote on the amendment.
Further discussion on the amendment?
Mr. Chairman.
Representative Chestnut.
I'm happy to work with Representative Crago and Oakley if she's interested on a committee of the whole amendment. I do think there are some language issues here that we need to clear up. As long as we're in this section amending it, let's make it clear. And I'm happy to. I would withdraw this amendment if we can have an agreement to work on a committee of the whole amendment before it comes up in a day or two. As a committee of the whole.
Question for the committee. Is there a sense that we can address this in this bill, given the title of the bill?
Mr. Chairman. Mr. Chairman.
Representative Chestnut.
The catch title says, or the title says, well, the catch title is amendments. This would be an amendment. Yeah, I think it's within the title. I do believe it's within the title personally.
Representative Harrelson.
Thank you, Mr. Chairman. So my only concern is if we start addressing this area to keep it congruent in the statutes, we almost need to address another area, and the Pandora's box gets opened. And then we have one word missed on a judiciary cleanup that makes it where you have to have four things to make theft actually wrong. And so, I mean, I'm bringing back what happened in a prior time, obviously, but the point is the floor is probably not the place to try start cleaning up pre-existing statute. Because that's gonna be a 2 hour long slog fest that we don't want to have on the floor. So I agree that this probably isn't the best wording, but I also know that that's almost more of an interim cleanup conversation where we go through with all of the attorneys' minds to make it better. I don't know. I just think that if we're not careful, we're gonna fix one thing and then we're going to actually have a discrepancy in another area of statute, and we're gonna be back where we started, why we have this bill.
All right. I sense a urge to vote on the amendment. All those in favor of Representative Chestnut's amendment, which you have in front of you, say aye.
Aye.
Those opposed, no. That amendment has failed. Back on the bill. Any further amendments?
Mr. Chairman, I think
Representative Jennings.
I don't see any way to make the amendment that I'd like to. I'd like to help the clerks out and bring it all even across the board. But since the catch title says that this is about increasing, I don't see any way to make that amendment. So I guess I'm going to have to vote no on the bill.
Okay. Any other?
Never
amendment?
mind the amendment, Mr. Chairman.
Representative Oakley. Is there any interest in the Department of Family Services proposal? Saying none. Question on the bill. Roll call vote as Representative Oakley.
Thank you, Mr. Chair. I guess I just wanted to discuss a little bit this, the talk about the choice to raise rather than decrease. And, you know, we heard discussion about, obviously, we're all facing inflation, things like that. Well, of course, I mean, the courts and everywhere is facing those same pressures. So it costs more to run our courts, and it seems to me to be fair and to make sense to have the fee for the people who are actually using the courts. That seems more appropriate than just expecting it to come more from the general fund, which means everybody in Wyoming's paying for those services. I recognize it can seem expensive, but if you think about it, also having a district court judge at your disposal to, in essence, resolve your personal disputes. And that doesn't take into account the clerks and the having recording so you can get a transcript, all of that stuff. It's an expensive process. So as often happens, Wyoming is one of the lowest, even now, even with the increase, would be lower than other states in order to provide this very necessary, important service. And the reality is the person who's doing that filing is availing themselves of the court. I have a personal dispute. I have a problem. I have something that I need access to the courts. So it makes most sense for that person, I think, that I'm advocating, and obviously I'm a yes vote on this, that the person getting the service pay for it. So that's what this is doing. I think it makes sense to increase. We've heard a lot from the clerks. We know that the district courts and the courts are expensive, and that the reality is you have to pay your way. We believe in paying our way in Wyoming too, right? So with that, I am a yes vote and would ask for everyone else to be.
Further discussion on the bill. Representative Cragel.
Thank you, Mr. Chairman. Also an aye vote. We worked on this extensively throughout the interim. We had lots of testimony, and I would just point out, although no one mentioned it today, I think as somebody who occasionally practices in surrounding states, I mean, a lot of our surrounding states, the filing fee is upwards of $500, the original filing fee. And then there, on top of that, there's other fees. They don't have this cap within their statute necessarily that we do. If you file additional, certain types of documents cost additional fees on top of the filing fee. And so I think we're fairly lucky in Wyoming. It's as low as it is. And like I said, I'll be an aye vote.
Representative Jennings.
So thank you, Mr. Chairman. So I'd like to address those a little bit. One, in my tenure in the legislature, I have yet to see a government efficiency come forward, although we're asked to spend millions of dollars every year. We bring all kinds of things. And two, the argument that the people around us are not doing it. I think that was answered by our mothers many years ago. If they all jumped off the cliff, are we going with them? I don't know of any state around us that has the kind of money that's in the black like we are. We're a small population. We're a rural population, and our fees shouldn't be as high as others. I would argue they shouldn't, because we've been blessed in this state to have tremendous resources. And so if we're not going to use those resources to help our citizens, I mean, I could support something that came along and said, shift $400,000 over to the system from somewhere else. We're flush with money. It's not the time to go after our citizens. The part of being on parity, one fee with the other, I'd be okay with dealing with that part, but I'm just not gonna go for any increases when we're, as a state and county, and I mean, if you'd ask any of them, they all feel like they want more money. So do my citizens, but they're not there. So anyway, I'll be a no.
Further discussion? Okay, I'll chime in my 2 cents. We did work this bill extensively over the interim, and we heard a lot of this testimony, and we saw how much the fees are in our neighboring states. And I think it's important that we keep in mind that, as Representative Oakley said, if the litigants who stand to benefit from filing the lawsuit don't bear these costs, those costs are then borne by all of our constituents, all of our taxpayers, that they share in that. And they're not going to receive a judgment at the end of the day in that civil filing. Somebody else is. And so it seems to me that the appropriate person to pay that fee is the litigant who's bringing the lawsuit, who's potentially going to, win a settlement or achieve a settlement or win a judgment in the litigation, rather than the average taxpayer who has no dog in the fight. That just seems reasonable to me, that we'd ask the litigants to pay those fees. And when you consider the overall cost of filing a civil lawsuit, the filing fee is probably the least expensive aspect of that entire process. That time you pay your lawyer and hire experts and yada, 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 the filing fee is hardly noticed on the part of the litigant who decides to bring a lawsuit. So I don't think it's unreasonable for the state to occasionally raise our fees. And I'm going to be a yes vote. So with that, let's have a roll call vote.
Representative Cragel,
Aye.
Representative Chestick,
Aye.
Representative Harrelson,
No.
Representative Jennings, Representative Nemec, Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams.
No.
And excuse me, I am so sorry, Chairman Washut.
Aye.
We have a total of 6 ayes and 3 noes.
Thank you, Madam Secretary. With that, House Bill 14 is passed Judiciary Committee. Do we have a volunteer to carry this on the floor? Representative Cragel, thank you very much. And with that, we'll move on to House Bill 12. Thank you all for participating in the discussion this morning on House Bill 14. House Bill 12. Do we have anyone in the room wishing to testify on House Bill 12? Welcome back. If you'd state your name and agency again for the record.
Mr. Chairman, members of the committee, my name is Christy Arneson. I'm the Senior Administrator of the Economic Security Division with the Department of Family Services, which oversees the Child Support Program. Mr. Chairman, I know this is a committee bill, but I'm happy to provide a little bit of background if that is helpful.
Please.
Mr. Chairman, members of the committee, the bill before you today is an update to the Wyoming Child Support Guidelines. Per federal regulation, as well as state statute, we are required to review the guidelines every 4 years. That year was 2020. Due to the pandemic, it was moved to 2021. When we conduct a review, we contract that out with an economist, Dr. Jane Venor, who is joining us virtually today. Ms. Venor conducts the review based on federal requirements. That review and that report and recommendations is then submitted to a committee, which is made up of policy team from the child support program, as well as child support attorneys, private attorney, the equal justice crew, a professor from the law school, as well as this year we had a parent who owes child support participate on that committee. The recommendations in the report for this go round recommended updates to the tables, which you see in this amendment, in this bill. Those tables have not been adjusted in 10 years. Well, the last time they were adjusted was in 2013 based on 2012 data. So as you'll see, the committee looked at this. We understand that there has been a difficult time over the past few years for everybody. However, the committee decided that it was prudent to put this bill forward to the Joint Judiciary team as an interim topic and recommended the changes be made to these tables. There is an increase to the tables. As you'll see in the documents that we did provide, it's about on average a 12% increase for orders, which is much less than the price level increases. And I will let Dr. Jane Venor talk to any economic data or questions you all may have. But as the program and as the committee, we are here today we support this bill and we believe that it is a necessary change to the tables. However, understand and recognize that as a policy decision to be made by this group. So I'll stand for any questions. Thank you.
Thank you, Ms. Arneson. Now, can you explain how this works on the ground, that these are presumptive and then courts deviate based upon some factors?
Mr. Chairman, yes, you are correct. In the statute, they use the tables to create a presumptive child support obligation. The judge, based on the circumstances of that case, has the ability to deviate upwards or downwards. There is a list of deviation factors within the statute that they can utilize.
Any questions for Ms. Arneson? Seeing none, why don't you stay close just in case something comes up.
Thank you.
And our economist is online, is that right? Is it Dr. Venor? Is that correct?
Yes, thank you, Mr. Chair.
Please tell us what we need to hear about your work on this bill.
For the record, I'm Dr. Jane Venor. I'm an economist with Center for Policy Research. We're based in Denver. We're a nonprofit organization that provides technical and evaluation assistance to programs affecting children. And I've provided technical assistance to about 25 states on the child support guidelines. And just briefly, yes, the schedule hasn't been updated for almost a decade, and prices have increased about 19% since then, but there's also been increases in wages. So Ms. Arneson's correct that there's an average of a 12% increase. And I'm going to leave it to the committee to ask me questions where they may have questions.
Thank you. Questions for Dr. Venor? Seeing none. Dr. Venor, can you tell us just a little bit about the process you use to evaluate where these increases are need perhaps to occur? What's the work that you actually do on the ground?
What we do is there's economic data on how much it costs to raise children. It's based on national data. The studies are conducted periodically by economists out of Notre Dame, but it's not in a format that is congruent to a child support schedule. It's based on expenditures, not on after-tax income, which is the economic basis of the Wyoming guidelines. So we have to translate that, and we have to take out the childcare expenses because that's obviously highly variable from case to case. So that's treated as a deviation in Wyoming, and the same with health insurance, that's actually an income deduction. And so we make those sort of adjustments. And then obviously they're lagging when the data are collected from families. It's a survey of, it's the Consumer Expenditure Survey, which does 6,000 households every quarter. And we grouped it by about 6 years. So we have to adjust that for inflation. So we use that to assess it. There's 33 states that are based on that data. Then we also check it against Wyoming price levels, whether it really if there needs to be adjustment for a state specific higher or lower prices. We also check it against a few other estimates of childbearing costs, such as the USDA produces some estimates that are, most economists think they overstate actual childbearing costs. So it's a useful benchmark to see if what we do is too high. There's a couple other studies that we check it against. We put together the data. And if you look at the executive summary, there's a graph that shows what those increases are by range of income. And you'll see that the increases are smaller at lower incomes, or closer to 7-8%. And when you get into the wages of about 13,000 net, which would be more of a surgeon, then it gets to be about 20%. So it gets bigger as income increases. And there's two factors that cause that. One is inflation, which obviously is going to, for somebody that has a bigger pool of expenditures, that's going to blow up more than somebody that has a smaller pool. And then the other thing that's happened is that we actually see an economic trend that those higher income folks are spending more. So I'm going to stop there because that was a lot to digest, and see if there's any follow-up questions. Thank you, Mr. Chair.
Thank you. I do have a follow-up. I look at the difference on the proposal and the variance between families with 1 or 2 children versus families that are larger. Can you explain the rationale for different funding levels depending upon the number of children? Seems to me just a little, I'm not sure the economy of scale that you suggest here is actual.
Thank you, Mr. Chair. Certainly. And, one thing that on the ground, sometimes you expect across the board, 12% increase for every single income, every single family size. And that's actually not what happens over time. I mean, you have to remember that culturally or, socially, economically, we've changed a lot in the last 10 or 15 years since the data that forms the basis of the existing schedule. And one thing that we noticed that has changed is that expenditures on family size have changed. And we noticed that, use the term economies of scale, and that's exactly the technical term, is that we've sort of lost our economies of scale of having more children. It used to be, if you had a family farm, it might behoove that family to have more children because they can work the fields. And what we're seeing now is that economies of scale is being lost, that you don't always, or families don't always put 2 children in the same bedroom. Everybody's got their own bedroom. So it's changed. So it's not that equal 12% for 1 child, 2 child, 3 children. It varies by the number of children because we've lost that economies of scale.
Thank you. Any other questions for Dr. Bernard? Seeing none, thank you for joining us today. Appreciate your testimony.
Thank you.
Anyone else in the
Mr.
room wishing to testify on House Bill 12? Anyone else in Zoom land on House Bill 12? Committee, your preference? Moved by Representative Craigo, second by Representative Oakley. Discussion or any proposed amendments? Proposed amendments? Seeing none. Discussion on the bill. Seeing none. We'll have a roll call vote.
Thank you. Representative Craigle,
Aye.
Representative Chestick,
Aye.
Representative Harrelson,
Aye.
Representative Jennings, Representative Nemec,
No.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
Chairman Washit.
Aye.
We have a total of 7 ayes and 2 noes.
With that, House Bill 12 was passed House Judiciary Committee. We will meet again on Wednesday morning. I don't have the bill numbers in front of me. We will be noticing a couple bills for Wednesday morning at 8 o'clock. Very good. With that, we'll